Proceed.
My name is Richard Filson. I represent the appellant, Lisha Stoddard, as personal representative for the estate of Melissa Stoddard. By way of background, I think you understand from the briefs that are filed that this is a case against what we call the technology defendants, which would be IBM, Microsoft, and CGI Technologies. They all participate in the creation of a web-based abuse reporting system for DCF, and we allege in the third amended complaint that as a basis for liability, theories that are premised on duties arising from the general facts of the case, the Undertaker's Doctrine. Essentially, these defendants were engaged to create a web-based abuse reporting system to supplement the telephonic system that already existed. It was a working system, the telephonic system. I think we've alleged that. And we're alleging that the basis for liability is that number one, the system didn't work initially, and that abuse reports were flowing into the system and ending up in cyberspace. It was, in other words, DCF was getting them into their computer system, but they were not flowing to the intake counselors, which is the way it was designed to occur. Beyond that, they did not warn, having knowledge that the system didn't work. End users, people that were making reports, were not advised or warned that the system didn't work. So that, as in this case, a mandatory reporter, school teacher, Paul Squeo, attempted to use the web-based system. It's alleged that he thought he did, and that, but on the other hand, DCF, of course, indicated, well, we never got anything. I spelled it out in the complaint that after records requests, after Melissa tragically died as a result of abuse by her parents, I was able to determine that this information did get into the cyberspace, but it did not flow to the intake counselor to be investigated. All of these, whether it's a foreseeable zone of risk under McCain or Undertaker's Doctrine issue under Clay Electric and that type of case law, it all boils down to, was there, and I'll just go to the Undertaker cases. Clay adopted the restatement of torts as Undertaker's Doctrine that provides one who undertakes gratuitously or for consideration to render service to another which he should recognize is necessary for the protection of a third person or as things is subject to liability to the third person for physical harm resulting from his failure to exercise reasonable care to protect his undertaking. If, before I get to the if part, clearly, Chapter 39 provides that the children's safety is paramount in this state. The Supreme Court in the Muni case versus HRS long ago held that DCF has a duty to protect children from further abuse once an abuse report is received by them. So clearly, the contractual language, actually we attached the contracts, references the Bajarona case as the reason that DCF wanted this new system because the system had failed. That particular child was a notorious case out of South Florida. Normally I couldn't raise it, but it's pled, number one. Number two, it was actually inserted into the contract with IBM. So having said that, the conditions, if A, his failure to exercise reasonable care increases the risk of such harm, or B, he has undertaken to perform a duty owed by the other to the third person, or C, the harm is suffered because of reliance of the other or the third person upon the undertaking. I think that the A and C are the most relevant here.
So in essence, your argument is anyone who is negatively impacted by the hotline who reported, so this in essence could be open to a class, I suppose.
I suppose it could. In other words, they had a duty to anybody.
To everybody who reported, who they didn't act on, or where it went into cyberspace.
Where it was lost. Yes. Yes, I agree with that. Yes, the persons that relied are going to see, kind of in reverse order, the harm is suffered because of reliance of the other or the third person upon the undertaking. In this particular case, it's alleged that Mr. Squeo, it can be inferred that he was relying on the system to work when he made the report. DCF was certainly relying on the system to work so that reports could be received. Going on above that, his failure to exercise reasonable care increases the risk of such harm. Is similar to the general facts of the case argument. I'll make them both at the same time because they're essentially the same thing. You've got a system that they created.
But the person relying isn't the one suing.
Right. It says the harm is suffered because of reliance of the other or the third person upon the undertaking. So the other can be DCF, and the third person could be the victim, essentially. Or actually, the other could also be Paul Squeo, the mandatory reporter. As far as increasing the risk of harm, creating a system, a web-based system that doesn't work, knowing it doesn't work, and not letting anybody know it doesn't work is certainly increasing the risk of harm. The whole system was designed, again, to protect children from further abuse once an abuse report's received. Now, an argument was made that to the effect that, well, the special relationship exception, you can't, hold a defendant liable for the acts of criminals. In other words, that breaks it. I think that the burglar alarm cases, negligent security cases I cited, they fall under the same exception. In other words, they're all bad law if you accept that as a total killer to the argument.
But in those cases, isn't it I contract with you for an alarm system, and then your alarm system doesn't work. So it's not some third party that's
if you look at
making the claim.
The cases that I cited, and that McCord case is directly on point, says privity isn't necessary. If you look at them, most of the plaintiffs are tenants.
Okay, let's say you own a consignment shop and you have an alarm system.
Right.
And it fails, and somebody breaks in and steals all the merchandise. All the individuals who consigned merchandise to the store would then have a claim against the alarm company for the loss of the goods?
I guess that's a foreseeability argument, like on the cases that involve tenants who are sexually assaulted, that sort of thing. You could make that same thing with them. They're obviously not contracting with the alarm company to provide them direct security. They're not in privity at all. But foreseeable criminal acts. Well, what's the purpose of this alarm system, the abuse reporting system, to keep children from being abused or continue to be abused?
It's to report, to accept reports so that investigations can occur to see if children are being abused.
Well,
because having a reporting system isn't going to have any bearing on whether a parent's abusing their child. It may have bearing on the discovery of that.
As an alarm system, because certainly an alarm can ring for many different reasons, but the purpose of it is to prevent theft, sexual assaults, batteries, etc., criminal actions on the property. So that argument would apply in both cases. In other words,
in those instances, they're actually creating the risk by failing to install the equipment properly. Whereas, what is the controlling mechanism here? How is this failure creating the risk that children are going to be abused?
Okay. An alarm system, of course, is a warning system that the criminal activity is occurring and requires a response by law enforcement to go out and investigate and to prevent further harm. In this particular case, you've got an abuse reporting system that would alert DCF. According to Yamuni, DCF has a duty to protect further harm once an abuse report is received. So they're in the role of the police, and they go out and do the same thing. So essentially, the burglar alarm cases would all be bad law if that argument was taken to the extreme, because, of course, an alarm could be a false alarm, could be, if the person is being sexually abused versus they're stealing property from the store, well, then that's not allowable. But all those cases, you don't seem to distinguish. They seem to look at foreseeability. And in terms of foreseeability, the purpose of an abuse reporting system, I'm at least arguing, I know there's maybe disagreement, is to alert DCF of the potential of a child being abused or neglected so that they can act to protect that child. Chapter 39 provides for that. The state has evinced, there was public policy arguments made in the lower court, but I would say that the state has, through the legislature, indicated that it's a paramount concern to protect children. If I reserve 2 minutes?
Sure.
I forgot to ask, sorry. So essentially, under the undertaker's doctrine and the general facts of the case, there are sufficient allegations of duty. This is I can't see of a more foreseeable, in terms of foreseeability, of creating a system and not warning. Now, then you've got the failure to warn case law, and I cited the FPL Goldberg case. In that particular case, the FPL deactivated a traffic light. It was an imprivity with the motorist driving through the intersection, but they deactivated it. Common sense indicated that it was very foreseeable. People were going to crash into each other, and they did, and FPL was sued. And the court basically found that even though there was, well, basically in a case where there was no privity, they didn't find it, there was no privity alleged, that it was foreseeable, and that based on the general facts of the case, it created a dangerous situation. The important thing that I want to say more than anything else is in terms of increasing the risk, there was already a working telephonic system that's been pled. So had Mr. Squeo and other potential users been warned, don't use the system, it doesn't work, he had an alternative. He could have called in the telephonic report. So clearly, this increased the risk to children for whom abuse reports were received. And that's the class we're talking about. Not all children, just children for whom abuse reports were received on the web-based system. Finally, there was an argument made by the appellees regarding immunity under Chapter 39.203. The case law that's cited in the briefs clearly indicates, and I don't think there's anything to the contrary, that the immunity statute applies to overzealous acts by the department or social service agencies, not for negligent acts for failing to protect children. Floyd case is on point, although it deals with the predecessor statute, but the predecessor statute had the same language. Finally, in paragraph 40 of the complaint, we indicate that the technology defendants knew of the problem and actively concealed the problem, so I don't think a good faith immunity argument can be made. So unless you have any other questions, I'll sit down and wait for a rebuttal. Thank you.
Give him about 5 minutes, Mr. Filson.
5 minutes.
Yeah.
May it please the Court, Marie Borland on behalf of the technology defendants. This is undeniably a horrific case. The circumstances that led to the death of this child are horrific, but that does not justify overriding what is clearly settled Florida law on the issue of duty as a matter of law. Counsel for the appellant is talking about the undertaker's doctrine, talking about the facts of the case, but the test to be applied is in McCain. Did the technology defendants, by contracting with DCF to provide technological services to upgrade the abuse hotline, did they create the risk that the Stoddards were going to abuse Melissa Stoddard? Of course they did not. That is the test, and it's very clear, and it's been applied in legions of cases, and legions of courts have dismissed cases under similar circumstances in the sense of there being no facts supporting the existence of a creation of a zone of risk that a particular harm would occur. And make no mistake, the particular harm in this case was the abuse. We have an even more narrow case because we are dealing with the criminal acts of third parties, and that's the special relationship exception to the general rule. There is a general rule that there will be no liability if the issue at question has to do with the criminal misconduct of third parties. That's what we're doing. That's what we're dealing with here. We're dealing with the criminal misconduct of the Stoddards. They are in prison now. The perpetrators of this horrific act are in prison, and that's where they should be. But there is no body of law, and in fact, the law that is well settled upholds the fact that the technology defendants cannot be held liable for their misconduct, their criminal misconduct. There are three prongs to this test. Were the technology defendants in control of the instrumentality of the harm? Clearly not. They were not in control of what the Stoddards did to abuse this young woman. Were the technology defendants in control of the premises where the harm was committed? Of course they were not. They had no control, no relationship whatsoever with the home where this abuse was committed. And were the technology defendants in control of the tortfeasors? Of course they were not. They don't know the Stoddards. They don't know Melissa Stoddard. They didn't know the Stoddards. So the test, we need to be very clear. The test is the McCain zone of risk test. It has been stated in the Aguilla case, Aguilla versus Hilton, that really what McCain is saying is, did you, defendant, create the risk that the harm would occur? And again, we don't have any set of circumstances, any facts pled that could possibly support the proposition that the technology defendants created the risk of abuse. And then we, again, have the more narrow test of the criminal misconduct of third parties. There we have to apply this more narrow three-point prong that I've just gone through that absolutely cannot be satisfied under the allegations of this case.
How would you respond to the suggestion that the risk here, you have children who are being abused, and that's sort of the class of people who are in the zone of risk if there is one, but the risk is that the child would be killed, and that the purpose of the undertaking was to establish a reporting mechanism so that DCF could prevent that sort of thing, and it was to be established to replace the previously existing reporting system.
And Your Honor,
isn't that really what the zone of risk is? Not that the child would be abused, but that the abused child would be killed.
That proposition, of course, that's the appeal. This is a very emotional case, so of course that's the argument.
Stick around and wait for one later on.
That's the argument that's being made, but we have to be very careful to look at what Florida law says. And there's not one case that would say that the zone of risk or the harm in this case was a defective reporting system, which, by the way, for the record, we don't believe there was any defect in the reporting system, but we have to accept as true these allegations. But that is not the zone of risk that McCain and all of the cases subsequent to McCain talk about. The risk is the harm that occurred.
The harm that occurred was this child was killed. I mean, I don't know that you can take one zone of risk case and say it didn't define another zone of risk case that way, because every case is different. Right,
right,
Your Honor. Every case has its own zone of risk, and that's what McCain's about. You don't develop hard and fast rules. You say if the conduct or the omission creates a zone of risk, whatever it may be, in whatever realm, that creates a duty to lessen the risk or warn. Right?
Well, Your Honor, I understand what you're saying, but I will say that having read many zone of risk cases, and purposely for that point, to look into that point, because that is the point that's being made, it is always the danger that occurred. In the Aguilla versus Hilton case, the zone of risk wasn't, well, you let this drunken, kid on spring break go out and then he hit. No, it was the collision. And the hotel, they didn't have a relationship with the young woman who was killed in that collision. They had nothing to do with that collision. One could say it was foreseeable. It was foreseeable that this person who they put out on the street would go and jump in a car and kill someone, but the case law says foreseeability alone is not the test. And again, in the Clay case that counsel has cited for the, quote, undertaker's doctrine, that was a electrical maintenance company whose job it was to make sure that those lights were working. And what's the purpose of a light on a road? It's protection. So they were in the business of protection. They were in the business of making sure that light, they created the risk that someone in the dark would be hit by a car, which is what happened in that case. So it's not just one case. If Your Honor, if the court were to look at all of the zone of risk cases, it is always the harm that occurred that is the risk at issue. And here, of course, the contention is made that it was the alleged defect in the web-based reporting system, but that is an issue between.
Well, it wasn't just that. And correct me if I'm wrong on this, but I thought that the complaint alleged that the technology defendants went live with this reporting system, and when they did that, they knew that it wasn't working properly, and that they didn't advise people of that. For instance, if you went in to make a report through the web-based system, you didn't get some disclaimer saying you better call because we're just testing this right now. I mean, isn't that what they're alleging?
Yes, Your Honor, they are alleging that, and not only are they alleging that.
So if an abuse report comes in and there's a possibility that it's going to get lost, I mean, doesn't that increase the risk that an abused child could be further abused or killed?
That is an expansion of the law that does not exist.
Why,
So-
though? I mean, why? I mean, I'm having trouble with how this zone of risk is being defined here, because it certainly doesn't apply, for instance, to children who are not being abused or for whom there is no reason to suspect, right? Because there's not going to be a report or one that DCF would investigate or act on. It would apply to people who I think are in this zone of risk are abused children. And when you consider that, you're not being accused of causing the abuse. You're preventing the discovery of the abuse by the agency charged with protecting the child.
I understand what Your Honor is saying. So I'll go back to what I said before. The risk that Your Honors are discussing are the risk that the system might not work and the risk that a report might not come through. There is not one case in the state of Florida that would support expanding a duty from that breach of contract to every child in the state of Florida. That is what the plaintiff has pled, that these technology...
Abused child.
Every child, to protect. The allegations of the Third Amendment complaint are that these technology providers, by contracting with DCF to assist with the upgrade of the abuse hotline, stepped into DCF's shoes and subsumed a duty of care to every child, to protect every child in the state of Florida. There is nothing in Chapter 39 that would support that proposition. There is nothing in the contracts that would support that proposition. And there is not one case that has extended the analysis that way. As I mentioned before, every case I have read, the zone of risk is the danger that occurred, not the danger that a report might not go through, not the danger that perhaps a report wouldn't go through and perhaps an investigation wouldn't be made. It's the danger of what happened in the house of this young woman. That is the way the Florida courts define zone of risk. So, Your Honor, I could see DCF having a heck of a claim against the technology defendants if, in fact, the system didn't work, which, by the way, we're not aware of any. But this is a matter of contract between DCF and the technology defendants. DCF, by statute, owes a duty of care, but the technology defendants do not step into DCF's shoes. There is no body of law in this state that would support that proposition. There's one case that I thought was particularly helpful in understanding this. And again, I know Your Honor said you can't just rely on one case, but it's the Knight versus Merheeg case. And it's the case where the parents invited their behaviorally challenged son to come to a holiday dinner, knowing that that son had expressed violent statements towards other family members. But they wanted to include their son in the family dinner, so they invited him. Tragically, when he showed up at the family dinner, he went and he got a gun and he shot and killed many of the family members. A claim was brought again by the estate of these individuals against the mother and the father. And the court, I would have thought that would be not only a foreseeable circumstance, but a circumstance where the parents were in control of the tortfeasor, they were in control of the premises, possibly not the instrumentality of the harm. I don't believe they provided the gun. But the court said, and it's very similar, I think, to this case, the Merheeg's invitation, as their primary issue on appeal, the appellants argued that the trial court erred in dismissing their complaint since the Merheeg's invitation to Paul to the family gathering created a foreseeable zone of risk given his propensity for violence towards certain family members. That's exactly what I think is happening here. The appellants are making the argument that, well, this was a foreseeable zone of risk. They say, in making this argument, the appellants characterize the issue of legal duty as one of foreseeability and nothing more, which I think is what's being alleged here. It's foreseeable that if this abuse hotline doesn't work, that someone could be injured. And that a plaintiff's interests are entitled to legal protection whenever a personal injury is a foreseeable consequence of a defendant's conduct. That's what's being alleged here. That is a foreseeable consequence of the fact that the abuse hotline might not work, that someone could be injured. But the court said, recognizing that this is a case where plaintiffs seek to impose liability upon defendants for the criminal acts of third parties, we reject this approach for two reasons. First, the imposition of a legal duty in this type of case is tied to either a special relationship between the plaintiff and the defendant or the defendant's control over the premises, the instrumentality, and the person causing the injury. So that's what I've argued here, that that's the test to be applied here. This is a criminal misconduct of third-party case. We have a three-pronged test that has to be fulfilled. I wonder what an opinion from this court, how it would read and how it would override that three-pronged test. I cannot understand how the court could write such an opinion. But what's really interesting about this case too, and
This court might say, hold my beer. No, I'm teasing.
Right, this might, well, anyway, but we hope we don't get there.
Right.
But even, so I would have thought in this case that liability would have been imposed. I think that arguably that three-pronged test was met. But what's interesting in that case, and I think is equally applicable to this case, the court went on to say that second, even assuming that the issue of legal duty is one of foreseeability alone, untethered to any special relationship or issue control, which again, in our case, the claim in this case is untethered to any special relationship or issue of control of the technology defendants over the Stoddards or Melissa Stoddard. Public policy reasons warrant a denial of liability where a defendant's conduct involves the inclusion of an adult family member into the extended family circle. So the court goes on to say that considerations of public policy are appropriate in determining whether a negligence cause of action will lie. Here we have a clear public policy. Not only, I don't think I have that power.
Time's up. No.
I'll happily sit down. Not only do I believe that the test has not been satisfied in this case, but the public policy considerations at play here, I would argue, and under Knight versus Merheek, warrant an affirmance, because who in the world is going to contract with DCF if by contracting with DCF you are deemed to have stepped in the shoes of DCF and to owe a duty of care to every child, to protect every child in the state of Florida? No one's going to do business with DCF. What if the lights go out and the electrical outlets, the electricity goes out or the internet goes out and an abuse report does all of a sudden, is the electrical company or the internet company or internet service provider, are they on the hook? As a matter of public policy, we know DCF is already up to its ears in what it has to do in this state. And we cannot afford, as a matter of public policy, to impose liability on parties like the technology defendants in this case. So, and in fact, in our statutory immunity argument, we disagree with counsel for the appellant, and the language of the statute does not support that the immunity only exists to acts of overzealous acts by DCF. It in fact says, any person participating in good faith in any act required by this chapter shall be immune from any civil or criminal liability which might otherwise result by reason of such action. Any person participating in good faith in any act required by this chapter is entitled to immunity. The technology defendants were participating in an act required by the chapter in providing these upgrades to the abuse hotline, and absent a lack of good faith, they're entitled to immunity. So we have a clearly stated public policy to protect people like the technology defendants. So I would say the public policy issue is twofold.
That statute, the intent of that statute, was that broad, or was it really intended to protect people who report?
Your Honor, it wasn't, because there's actually an or in the middle, and yes I do, I have the statute here. I asked the same question. It says, any person, official, or institution participating in good faith in any act or reporting in good faith any instance of child abuse shall be immune. So it is a two-part statute. You're either participating in good faith in an act required by the statute, which the technology defendants were, or you're reporting, which is something different, but it's an or, not an and. So it is meant to protect service providers, or providers like the technology defendants and others. So again, the public policy argument would be twofold. One, we've got to protect DCF and the ability of DCF to have people contract with that agency. And two, as a matter of, the Florida legislature has said that parties in the position of our clients are entitled to statutory immunity. And we asked, under the Tipsy-Coachman doctrine, that the court also consider statutory immunity as another grounds for upholding the dismissal. And for all these reasons, given the McCain,
Sorry, that guy's up there, and I'm saying it's not me.
Like, am I touching
Sometimes
anything
it's
like I
me.
shouldn't be?
But it's not me.
this is a first for me in 30 years of arguing appeals. I've never had flashing lights. Maybe that means I should sit down. But for all of these reasons, unless the court has any additional questions, we would ask that the court affirm the trial court's order of dismissal.
Great, thank you, Ms. Borland.
The Third amended complaint is not that broad. The class, or the children in the zone of risk, are children who are being abused for whom an abuse report was made on the web-based system. This is all children in the state of Florida, so that there's going to be overwhelming liability for anybody that contracts with the state. And the complaint
Well,
is...
although you couch the complaint that way, yeah, it's not, this isn't like a class action. The
It's not a
question
class
is,
action.
In fact, is there a zone of risk, and who is in the zone of risk?
Right. So, having said that, this cause of action isn't just for either the technology defendant coming in and negligently creating something that doesn't work. This is a claim for a negligent creation of the abuse reporting system, the web-based abuse reporting system, and then going live and then concealing it. So it's a little more complicated than a situation where a contractor comes in and creates something that doesn't work. It's more than that. Now, the case that I cited, I think I was referencing about the lack of privity. There was one that went directly to it, and that was Travelers Insurance Company versus Security Link. And in that case, the court stated the security company contends that it owed a duty only to the alarm company with whom it contracted. However, Florida law is well settled that a non-contracting party may bring an action for breach of a contractual duty when the party is the intended beneficiary of the contract. And then you go through these. They talk about intended beneficiary, but they're all they're negligence cases. And then I would point out that at least in terms of IBM, looking at their particular contract, it stated in the contract and alleged in the complaint that the master statement of work further states that the following business capabilities and processes that have been identified by DCF as being important to the safety and children and families within the state of Florida. I mean, it couldn't be clear that children are the intended beneficiaries of the actions of not only the contractual obligations, but the voluntary actions that the technology defendants conducted in creating the system. But then, of course, our claim is that they created it, it didn't work, they concealed it. And that others like in the Undertaker's Doctrine, the other people like Paul Squayo, a mandatory reporter, relied on it, used it, it didn't work, and as a result, Melissa would continue to be abused and later die. Thank you.
Thank you, Mr. Bilson. Thank you.